Thank you for joining us on Heritage Events Live. We're delighted to welcome you to Restoring American Leadership in Patent Law and Innovation Policy. Please welcome our host, John Malcolm, Vice President of Heritage's Institute for Constitutional Government. We hope you enjoy the program.
Well, welcome everybody to the Heritage Foundation, those of you who are here in person and those who are joining us virtually. In a recent Heritage paper entitled The Constitutional Protection of Intellectual Property, one of our speakers, Adam Mossoff, argued that the founding era documents made it clear that intellectual property rights, including patents, are property, every bit as tangible and real property. And that they are protected by the Constitution. And he also pointed out that for courts, including the Supreme Court in the 19th century, vigorously protected those rights. But as Bob Dylan once wrote, the times they are a-changin'. Patents and the entire U.S. patent system are under attack, and from many quarters too, both here and overseas. We've assembled an excellent panel to address recent developments in patent law and the ongoing threats to the patent system and the consequences, both those that have already been realized and those that might still occur. So to my left here is Adam Mossoff. Adam is a professor of law at the Antonin Scalia School of Law and a senior fellow at the Hudson Institute and a visiting fellow here at Heritage. He's a graduate of the University of Chicago Law School and he clerked for Judge Jack Weiner on the Fifth Circuit. He's testified several times before Congress and has published extensively on why intellectual property rights have been and should be secured to innovators and creators as property rights. His writings have appeared in numerous scholarly journals and periodicals, and his research has been relied upon by many courts, the Federal Circuit, numerous federal agencies, and the Supreme Court. To my far left is Lori Self. Lori is a graduate of the University of Virginia Law School. She's a senior vice president and counsel for government affairs at Qualcomm, where she specializes in intellectual property and related policy matters. Prior to joining Qualcomm, Lori was a partner in the Washington, D.C. firm of Covington and Burling, where her practice focused on U.S. and international technology law, with a particular emphasis on intellectual property law, compliance, and enforcement. And joining us virtually is Andre Iancu. Andre is a partner at the law firm of Irell and Manella. He has a master's degree in mechanical engineering and a law degree from UCLA, where he also has taught patent law. He previously served as an Undersecretary of Commerce for Intellectual Property and as Director of the U.S. Patent and Trademark Office, a position to which he was confirmed unanimously by the Senate, which was something of a rarity among people who were nominated by the Trump administration. As head of USPTO, Andre oversaw one of the largest IP offices in the world, an agency with approximately 13,000 employees and an annual budget of more than $3.5 billion. He also served as the administration's principal advisor on domestic and international intellectual property issues. This year, Andre co-founded the Renewing American Innovation Project at the bipartisan Center for Strategic and International Studies. He's received numerous awards, including the Excellence Award from the American Intellectual Property Law Association, and his work has been praised by publications way too numerous to mention. So, over the last several years, as I've just alluded to, there's been a lot of upheaval in the U.S. patent system, and it's come from all three branches of government, from the Supreme Court, from Congress, from the executive branch, primarily via agency actions at the Federal Trade Commission, the Patent and Trial and Appeal Board, and the U.S. Patent and Trademark Office. I was wondering, we'll start with you, Andre, if you could take a few minutes and outline why you think this is happening, and perhaps identify 2 or 3 or 4 issues in the patent system that you think are having the most significant impact on the innovation economy and also on our national security. Andre, to you.
Well, first of all, yep. Thank you, John, and thank you for the very, very generous introduction, and great to be with all of you. Sorry I couldn't be there in person. It is really great, though, to see that the events are beginning to take place in person, and the only reason I couldn't be there is because, at least this week, I am here in my in Los Angeles, in my office in LA, but I will be back in DC shortly. In any event, so to answer your question, well, look, first of all, let me just begin by saying IP is increasingly more important in our economy. It's been important for a very long time, frankly, from the founding of the country, but to a higher and higher degree on an ongoing basis. IP-intensive industries make approximately nowadays about 50% of our GDP, and you know, the attention being paid to these issues by the courts, by the legislature, by the administration, as a result, is increasingly more and more prominent. There's an increasing push and pull by the various industries that are for whom IP and innovation are becoming more and more important. So it's not a surprise, frankly, that there is so much attention brought to bear on the issue. Now, what are the main problems, though, given the increased attention from all the corners? Look, in my view, the biggest concern, the biggest cause of concern is the failure of decision makers to understand and make the connection between intellectual property on the one hand and innovation on the other hand. Everybody basically agrees that we need more innovation. Nobody's going to go out there and say, maybe the United States should be less innovative. Basically, across the board, folks say, yeah, we need more innovation. But unfortunately, I think a lot of folks, and even more unfortunately, an increasing number of people, including academics and policymakers, think that innovation just happens by itself naturally, and that IP is an afterthought, and perhaps it's just another, once the innovation happens, that IP is then a way to monetize it or collect on it somehow, without realizing that the IP is a fundamental, necessary requirement in order for innovation to happen at the scale that we need it in the United States. The key is a failure to understand that the United States needs intellectual property in order to ensure that the free market participates in the innovation economy. Without IP, the free market does not participate, or at least does not participate at the same scale. So to me, going forward, and we'll have a lot more to discuss in this, with specifics as the program unfolds, John, but to me, what we need to establish is a broad-based understanding of the critical need for IP to unleash the free market investment and effort that's necessary in order for the United States to innovate at the maximum of our abilities, so that we can increase our competitiveness, both internally, obviously, create more jobs and improve the standard of living of all Americans, but also international competitiveness in the face of competition from increased competition from China and many others around the world, at the cusp as we are of the next industrial revolution.
Lori?
Yeah, I could not agree more. I think, just to use Qualcomm as a case in point, Qualcomm is essentially the R&D arm of the mobile ecosystem. So when you think about each generation of a new cellular standard, you're talking about 10 years of R&D investments that precede that standardization process, which in our case is completely funded by Qualcomm. We do not rely on government funding, and that's true for the vast majority of R&D intensive industries in this country. Of course, companies in China have a very different dynamic, but in this country, we believe in a market-based system of innovation, which requires large upfront investments in R&D, and patents are critical to that. And just to build off of what Andre was saying, we see, and it's not limited to any particular party or administration. Time and time again, we see administrations issue policies that reflect a real misalignment between the aspirations of R&D leadership, technology leadership, and their policies on intellectual property, as Andre said, as if intellectual property is a kind of afterthought or an ancillary policy that really has no bearing on our ability to lead in R&D intensive spaces. And of course, in sectors like 5G or AI or in the life sciences sphere, without a strong patent system, there is no possibility of maintaining that R&D leadership position. And so in the current administration, and again, we saw it in the previous administration, we saw it in the Obama administration, there's a huge emphasis in Congress and in the White House policies on 5G and R&D leadership, and yet we're also seeing a series of policies that will, if implemented, undermine our patent system. Congress is in the process of putting together a huge omnibus package on China competitiveness, which is all about R&D investments in critical spaces without any focus on the importance of intellectual property to that R&D position. So again, this sort of cognitive dissonance or disconnect, as Andre was articulating, is something that's not only a pattern that needs to be addressed, but it's a vulnerability that needs to be addressed. In terms of why it's happening, IP skepticism is nothing new. I mean, as Adam has documented in his work, we've had patent skeptics since the beginning of the country, with Thomas Jefferson being, a notable case in point. And of course, industry sectors throughout our history have driven this sort of skeptical attitude towards the patent system, largely motivated by their own commercial self-interest. So the railroads of the 1800s have been displaced by, Silicon Valley. These are companies that largely depend on third-party technology and intellectual property. Not surprising that they would like to see that intellectual property come at a lower price, but the stakes have never been higher in terms of the fact that we are no longer at a point where we're competing with Western Europe over technology dominance. We are really competing with a different set of players that have a very different mindset towards technology leadership, and so we can't persist, I think, in failing to treat intellectual property as a core platform of R&D technology leadership.
And of course, that research and development can cost tens of millions or hundreds of millions of dollars and end up being a dry hole. I mean, the technology might not work, or the drug might not work.
Sure.
Someone might beat you to market. So it's sort of an assumption that, well, you invested it,
Right.
it will work, and we'll assure you get some kind of return. But
right, we are talking about technologies where failure is inevitable, and where you're pushing the boundaries of science. You're inventing technologies that current generations think impossible. And the fact that we as a nation have done that throughout our country's history, I think, is in large part due to a strong intellectual property system.
Adam?
Yes, I couldn't agree wholeheartedly with more with remarks by Andre and Lori. Today is a really auspicious anniversary in the United States. I don't know if everyone is aware of this, but today is the day that we heard the words, Houston, Tranquility Base, the Eagle has landed, in 1969. A feat thought literally impossible just a decade before we did it. And many of the innovations used to get us to the moon were patented. The lunar lander itself was patented. The chairs used on the command module in the launch rocket were patented technologies. I mean, the patent system, I often refer to as a platform for innovation, the legal platform, to kind of remind people that we don't just have platforms in technology, but I guess with today's anniversary, I really should refer to it as the launching pad. It's a launching pad, it's the legal launching pad for innovation, and it has been throughout the history of our country. The United States historically took the position that these were property rights. We were unique in that position, and it was a key feature for our success in the 19th century, where we displaced England as the primary location of the Industrial Revolution, which shifted from the 18th to the 19th century to the United States. And people often forget that how incredible that was, that when we broke from England, we were indebted, primarily an agrarian society, having suffered a massive war for a very long period of time. We've all seen the Hamilton musical with King George singing "You'll Be Back." That's a joke. We laugh at that, but people in England really thought that we would come crawling back to England to be welcomed back into the Commonwealth. And 60 years later, at the very first World's Fair at the Crystal Palace Exposition in 1851, we were marveling the world with our inventions and vulcanized rubber and the telegraph and the repeating firearm and mechanized reaper. It's unbelievable what the mechanized reaper achieved for us. And so many other innovations, the sewing machine. And of course, all of these were patented innovations. And in fact, the US patent system then spread throughout the rest of the world because people were like, oh my God, how did this happen? And people rightly attributed it to the US patent system. And Japan and Germany and many other countries started to replicate our system. And that system was a system of property rights, as I mentioned. It provided reliable and effective protection. And it wasn't just for incentivizing people to make the investments to create the inventions, because you could do that through lots of different legal mechanisms. You could do that through prize systems and tax credits and patronage systems and other types of mechanisms. But the key that patents provided that these other systems didn't was that they were property rights. And what that meant was that they didn't just incentivize the creation. They provided the bridge from the act of invention into the marketplace. They made it possible then to enter into the contracts and to obtain the funding. In fact, early innovators like Samuel Morse used their patents for venture capital financing, as collateral. And it has been shown repeatedly again and again and again that patents as property rights serve this key function of bridging what they call, for startups, the valley of death. You get to shift from becoming a startup to a small, medium enterprise and a successful contributor to our innovation economy. And that only works if it's a property right, if it's a reliable and effective property right, that you can be protected against infringements of it, and that you can license it in the marketplace, and that it won't be violated in the marketplace once you're successful. And this has all been lost in the past 10 or 15 years in the United States. Through a series of Supreme Court decisions, the Supreme Court has re-engaged with the patent system to a degree that we haven't seen in almost 100 years. It's now deciding cases at a rate we haven't seen since the 1920s and 1930s. Through regulatory actions, and where the FTC and other antitrust agencies take the position that patents are inherently anti-competitive, contrary to all of the economic evidence and historical evidence that patents are a driver of competition, a driver of the free market, as Andre mentioned. And through constant legislation that has weakened or outright eliminated patent rights. And so there's been this shift to thinking of patent rights as this kind of administrative entitlement. It's just part and parcel of economic policy or industrial policy that the United States engages in. And so we can tweak it and take it away and give it and things of this sort and constantly change it. But when you're talking about the type of time horizons that Lori mentioned, decades, it took us a decade to get to the moon. It takes decades to produce the next G and 5G. It takes decades to produce the next mRNA technology, platform technology, and so on and so on. You can't constantly have variances in your legal protections, where people won't make the investments, they won't enter into the contracts, and they won't create the commercial infrastructure necessary to convert inventions into real-world innovations that benefit patients in the healthcare sector and just ourselves in day-to-day life with our technologies like our smartphones and other things that we almost take for granted today.
So we'll talk in a little bit about a couple of those Supreme Court cases, and I'm going to sort of throw this open to any of you, and you should feel free, by the way, just to let me know you want to respond to each other. That's fine with me. So now let's go at what the major criticisms are. So you're going to get critics of vigorous patent rights. You could throw in copyrights too if you wanted to. They argue that the period of protection is too long, that the benefits are overrated, that the cost to society are too great. How would you respond to those critics, and sort of what is the historical and economic evidence that reliable patent or copyright rights increase jobs and and innovation, and there's a national security element to some of this too. You referred to the space landing. Obviously, we have national security products and systems that use patents too. So how would you respond to the people who say too long, too high a cost? Whoever wants to go first.
Well, I could start, John, if you'd
Sure.
like.
Go right ahead, Andre.
My question to them, to those critics is, and those arguments is, where's your evidence? Where is that evidence? Because the burden is on them. Here's the reality. The reality is that humans have been on this planet for, depending how you count, thousands, hundreds of thousands of years. They've been certainly organizing in civilized societies for thousands of years around the world. And yet, the state of the human condition just 200 years ago, when our modern intellectual property system was established, was the same as in antiquity. All right, just 200 years ago, when this country was founded, the best mode of transportation was on horseback, just like in antiquity. The best mode of communication was by carrier pigeon or something, or just like in antiquity. And anesthesia, best case for anesthesia was a shot of whiskey. And that was the best case, just like in antiquity. It took 2 weeks, to send news of the Declaration of Independence from Philadelphia to Richmond, Virginia. Just as long as it took Alexander the Great to send news of his win in the Battle of Arbela in 331 BC. All of the progress that we know of today, and we've gotten so accustomed to today and expect more of in increasing fashion every day, has happened under the auspices of this intellectual property system. So before folks try to do away with it or propose some, radical modification, it is incumbent upon them to provide the evidence that A, it is needed, that in fact we could have done better without our system, despite millennia of evidence to the contrary. And then it's also incumbent upon them to prove that whatever new system they propose is going to work at least as well for the United States as the current system that they try to replace. Any government, frankly, that is attempting to fundamentally change and weaken our traditional intellectual property system has a responsibility to its citizens to make the clear case that A, it is needed, the change is needed, and B, that whatever they replace it with will work at least as well and hopefully better. I don't believe that there is any such evidence that weakening intellectual property rights is going to improve anything. And in fact, all the evidence is to the contrary. The economic evidence is undisputed. I'll give you a small, just one statistic, which goes to one critical aspect of the intellectual property system, which is to enable the new market entrants, the startups, the initial investment to take on the established large entities. For a startup, and this is a study done under the auspices of the USPTO a couple of years ago, a startup that receives its first patent increases its employment and sales performance in the subsequent 5 years by over a third. That's just one first patent on average, sometimes much more. And of course, the more you innovate, the higher your likelihood of success. So there's so many other statistics like this that all point in the direction that a reliable IP system is critical for economic growth. So the folks who criticize this need to indicate why they think that is wrong.
And I'll add on that. And
Sure.
So I've been living the patent policy debate in Washington for about 15 years now. Before that, did a lot of work IP issues internationally. And if you want another data point, to Andre's point, look at the U.S. system of innovation versus the system of innovation in countries that historically have not had a strong system of property rights or intellectual property rights. But that aside, I think it's really important as we talk about these so-called harms that you strip away the rhetoric and this commercial self-interest and the pejoratives, trolls, et cetera, and take an objective look at the economic literature and as well as the historical underpinnings of our intellectual property system. One of the things that has struck me throughout the last 15, 16 years when I started to see a real shift in US policy away from an imperative of maintaining a gold standard patent system to a policy debate that was really about weakening intellectual property. But what has struck me since that point in time, which I would say started around 2005, is that it's very difficult to even engage in a fact-driven, economics-driven debate because so much of the policy is sort of steeped in this, in these sort of hypothetical fears around abusive litigation and trolls, and so I would just make a real plea, if you will, for let's look at the economic evidence, as Andre said, and the economic evidence is robust. Adam made the point that there are different models of innovation, government prizes, corporate prizes, outright subsidization. But for those economic historians and economists who have taken a look at which system of incentive, if you will, drives not just innovation, but a democratized entrepreneurial system of innovation. So in other words, you're not just funding a national champion or you're not shoring up the position of a already dominant incumbent, but you're really creating an environment where everyone has access to property through their own inventive, creative endeavors. The patent system, the copyright system, the intellectual property system is by far not just the best at doing that, it's really the only system that achieves that kind of prolific entrepreneurial economy. So, again, kind of going back to the sort of misalignment of policies, this administration, this Congress is very concerned about the, power, if you will, of certain dominant digital platforms. Well, let's think about how you address that. In my view, you address it by unleashing competing innovative endeavors. You dismantle that dominant position by creating disruptive innovation, an opportunity for disruptive innovation. And that's what the patent system enables. And by the way, many of those companies that are now in the crosshairs for being too big, too powerful, they have been systematically trying to weaken intellectual property rights in this country because they know that's a means of shoring up their own position. Again, I'm not saying that critically. I mean, it's their self-interest to do so. But as we talk about this issue around the pros and cons of the intellectual property system, let's strip away commercial self-interest and really look at the evidence, as Andre was saying, because I think the evidence is clear. And again, these issues are far too important to make policy based on rhetoric, based on anecdote, based on a corporate propaganda campaign around so-called trolls. And so I think it's imperative that we do take a hard and objective look at the evidence.
So you've alluded to patent litigation. I want to get to that in a few moments. Adam, you can answer the question I asked, but I want to give a specific example, and then you can respond how you wish. So Andre said, okay, so where's the evidence? Where's the cost involved from robust patent protection? And critics would respond with a very recent example. And the Biden administration is being quite responsive to this criticism. So in response to the COVID-19 pandemic, the World Trade Organization has proposed waiving intellectual property rights for vaccines. And over 60 countries and the Biden administration have announced their support for this proposal. This appears to be pretty much an unprecedented development. Why is that a bad thing? It's sort of feeding into what the critics would say, and here's a particular example.
Well, that's a great question. It's a great example, and you're exactly right. So South Africa and India proposed at the World Trade Organization to waive the entire, it's called TRIPS, the trade-related aspects of intellectual property rights, which is an international treaty agreement between all of the countries that provides for effective enforcement of IP internationally by ensuring that IP laws are adopted domestically in each country, and then if they don't do that, then you can go to the WTO and get trade sanctions against them. So it's not about what's happening in the United States, although if they adopt it under our treaty obligations, if the WTO adopts the waiver, we would then have to implement it domestically, and it would raise tremendous questions about takings and due process and things of that sort. But I want to be absolutely clear, because that there is zero evidence, zero, that patents or any intellectual property right has blockaded, impeded, or otherwise prevented the development of vaccines or any therapeutic treatments for COVID-19 or access.
I assume to the contrary, it's
In
spurred.
fact, it's the exact opposite. All of the evidence, as Andre highlighted and as Lori highlighted in a broader context, is that intellectual property has facilitated the development of these very treatments that are making sure that the COVID-19 pandemic, as horrendous as it has been, right, will not be a repeat of the Spanish flu pandemic of 1918, where an estimated 50 million people across the globe died at a time when the world population was 15% of what it is today, right? So, I mean, that puts in context. Yes, I mean, the deaths are horrible, but it is nothing compared to what past pandemics have wrought upon humanity. And who do we have to thank for that? We have the biopharmaceutical industry to thank for that. And who does the biopharmaceutical industry have to thank for that? The patent system and the intellectual property system more broadly, because that is what made possible the framework for them to invest the billions of dollars to create cutting edge technologies like the mRNA platform, which is what led to so many of our vaccines. And there's all of these narratives and rhetoric and false claims, as Lori mentioned in the context of patent trolls, in this space. So you hear like, oh, well, the government funded the mRNA vaccine. That's 100% false. In fact, it was such a radical technology that the people who were coming up with it in the 1990s couldn't get grants because people thought that they were crazy. And so they were able to use the actual intellectual property system to get venture capital financing of the sort that Andre described, to then continue to invest in the development of the technology, in the creation not just of the technology, but of the commercial infrastructure necessary to then deploy that technology in an effective way. You know, we refer to the Pfizer vaccine, but Pfizer actually didn't create the vaccine that it's distributing. BioNTech did, which is a small startup company that is one of the startups that actually developed the mRNA platform. They entered into a license agreement with Pfizer. So because BioNTech had the innovation capital, the idea, and Pfizer had the labor and capital to more effectively scale up production and distribute it worldwide in order to effectively get this vaccine out there, and in fact, in a miraculous time. And I mean, we all have heard Moderna actually created its vaccine in 2 days, which is true. So within 2 days after the Chinese researchers released in January of 2020 the genome for the COVID-19 virus, BioNTech created its vaccine in 2 hours. And so these vaccines were both in the hands of the FDA and were going through testing in February of 2020, which is just unheard of in human history. And this is all made possible by an intellectual infrastructure, a technological infrastructure, and a commercial infrastructure that was developed over decades through billions of dollars that were invested in the foundation of having property rights in the fruits of their productive and inventive labors. And so, to the extent that you hear, oh, there's this will open up for more vaccines. Manufacturing capacity for vaccines right now is 100%. They can't manufacture anymore. There's going to be somewhere an estimated around 12 billion doses of the COVID-19 vaccine produced by the end of 2021. Right? There's only I think 7 billion people on planet Earth. I mean, this is a truly amazing achievement that was made possible by human scientists, technicians, and companies that were structured and made possible by our IP system. And I will emphasize, actually, the evidence of the problems are evidence of government blockades outside of the IP system. So the inability or legal prohibitions against importing or exporting PPE, or even the vaccines. We're sitting on a massive doses of AstraZeneca vaccine that we won't distribute to our population because of it's less efficacious than Pfizer or the Moderna vaccine, right? Well, if you're in the developing world, you're happy to take a less efficacious vaccine. Why isn't that getting to them? Because we actually have a legal prohibition on exporting that vaccine to the developing world at the moment. That's not the patent system. That's actual other regulations and legislative controls that have been adopted.
Yeah, I should point out too that a number of the people who develop these vaccines are actually being quite generous in terms of the what they're charging some countries to get these vaccines because of the humanitarian.
Yeah, the Pfizer's CEO, when the United States announced that it was supporting the waiver proposal at the WTO, which is, like I said, unprecedented, both the waiver proposal itself and U.S. support for it. It's just never occurred in history. The Pfizer CEO released a letter where he said, look, I personally called leaders of developing countries and said, we will give you vaccine for free. And they said, we don't want it. This mRNA technology is untested. We're suspicious of it, so we don't want it. I mean, what can you do at that point?
To build on one thing that Adam said, and I could not agree more with everything he articulated, but there is a really important connection between having a strong patent system and maintaining that intellectual base. People, scientists, engineers, people who have the expertise to innovate in these highly complex spaces. What the patent system enables, and I think, John, you mentioned like the duration of the patent system, very often there is a significant time lag between the invention and your ability to commercialize that invention. And so having a patent system that allows for a period of time in which to bridge that sort of temporal gap, if you will, is critically important. But when you look at the vaccine situation, and I could analogize it to 5G, although obviously the vaccine in terms of the savings of life is profound. But what we do builds on decades of pre-existing technology and pre-existing intellectual know-how, if you will. And when you weaken the patent system in a market-based economy, you create not only disincentives to invest in R&D, you create disincentives for people to actually stay in those fields, to study in those fields, you create disincentives for companies to be able to hire the best talent in the world. So, we are our engineers. That's our lifeblood. And, if we can't continue making these big upfront investments, not only does it impede our ability to maintain that incredible pool of talent, but it also impacts the pipeline of talent coming through our university system. And we see that in a very real way with the engineering schools that are now educating our most talented engineers. A lot of those folks are going into areas of innovation that are candidly much more of the sort of digital platform model than they are of sort of hard R&D based wireless communications, and I'm sure that's happening in other fields as well. So I just wanted to make that point because I think it's a critically important point that patents not only enable or incentivize investments in R&D, they incentivize investments in a talent pool that once you've lost it, it's incredibly difficult to get it back. And you look at countries in Asia, for example, Korea is a good example, where they made huge investments in their talent pipeline, and it's paying off, in really important ways, for example, in the semiconductor industry. Again, we, I think, as a country, talk about how important STEM is and maintaining a STEM pipeline, but we fail to make those connections between our intellectual property system and our ability to not only incentivize young people to study in these fields, but to create job opportunities. If there's no employment opportunity that leverages your area of expertise, why on earth would you study in that field? And I think as we think about weakening of our patent system, we've weakened that talent pipeline.
So I want to make sure we have time for one or two questions, and so I'm going to combine three questions I was going to ask sort of into one. There is a common theme, which is you've referred to patent litigation, and Lori, at one point you made reference to patent trolls. So I'm going to ask her about three developments that have happened, and I'm going to call on each of you, and you can respond to whichever one of those three, hopefully maybe even different ones. So one is the patent troll issue, the sort of the development of private funding of patent litigation. That seems to be a relatively new phenomenon. Adam, you made reference to the fact that the Supreme Court has not only been dipping its toe in the water in terms of patent law, but really they're if not in the deep end of the pool, pretty close. And there are a couple of cases that have had a significant impact. One is a new one. So back in 2006 in the eBay versus Merck exchange case, the Supreme Court limited the ability of patent holders to get injunctions for violations of their patent rights. And then just this year, there was a case involving the Patent Trial and Appeal Board, which is, it's been controversial since it was created in the America Invents Act. It's resulted in 4 Supreme Court decisions, including this term's, U.S. versus Arthrex. And so you could talk about any one of these issues, general sort of trends in patent litigation, what the reaction has been, what this all means. And Andre, let's start with you.
All right, great. So first of all, before I get to those specific questions, John, let me just quickly comment on the vaccine waiver issue, because it really is probably the most important intellectual property issue of the day. I view the waiver proposal and the debate surrounding it and the administration's suggestion that it supports some sort of a waiver as tragic. I view it as tragic for at least 2 reasons. Number one, I think it will have a detrimental effect, the exact opposite of what the proponents are asking for. And I think it's going to result in more people getting hurt around the world from the pandemic and not less. That's number one. Let me explain that very quickly. Look, we're in the middle of new waves around the world, new variants. It is absolutely clear that more innovation, more treatments need to be developed, not fewer in the future. Knowing that COVID-19 technologies will be appropriated as soon as they are successfully developed, who in the private sector is going to invest the billions of dollars? Because now ahead of time if the if the waiver goes through, knowing ahead of time that it will not be protected, that investment, who's going to do that? And we are in absolutely critical need for treatments and additional developments down the line. And we need everyone in the private sector involved, not just the established firms, but up and coming startups, private equity, venture capital. Everyone needs to get in the game. So that's number one. Number two, this continuous international discussion about the waiver of IP rights, which will not get more shots into people's arms, in fact, most likely less. This discussion is masking the real issues behind inequitable distribution of vaccines around the world. And those are actual issues. It is actually important to have a more equitable distribution of vaccines around the world. Countries are in fact hoarding vaccines, and other countries are suffering as a result. Something needs to be done. Governments should not be permitted to hide behind this red herring of an argument surrounding IP waivers, and instead should focus the international discussion on the issues that really matter, that will, like export controls, as Adam mentioned, as local regulatory controls, as infrastructure issues such as refrigerated trucks for delivering of vaccine, as supply pipelines, and so on. Those are real issues that governments need to address on the international scale in order to get people around the world treated and vaccinated. And governments should not be hiding behind this issue of IP waivers, which will actually do more harm than good. So for those two reasons, and actually quite a few more, I think it's a very harmful proposal and harmful discussion. Now, to your question surrounding patent trolls, let me just answer one bit of that, and then I'm sure Lori and Adam have further thoughts. The rhetoric surrounding patent trolls and quote bad patents, or whatever is the term, pejorative term of the day, is and has been used for a long period of time, probably at least a decade, maybe two now, in order to drive a narrative that has taken hold pervasively in all circles, that IP is a barrier to innovation, which is a counterfactual argument, counterfactual narrative. We all know that IP, as we have discussed, has been a catalyst to private investment based innovation. And the sad part is that this simple phraseology, whether it's patent trolls or bad patents or whatever, is driving this harmful narrative. To one of Lori's earlier points, it is really dangerous for governments to make policy decisions based on such slogans and rhetoric. Let's be specific about the actual issues that you perceive, and let's put evidence behind them, and then let's address the real issues that actually do exist, if they do so exist. You know, China is a centralized government. They have a very specific plan of innovation for the next 5, 10, 15 years. We are a free market economy. If we kill intellectual property through these slogans or weaken them, and if that is going to weaken or eliminate private investment, what choice does a free market economy like the United States have left? If we disable our free market system, how are we going to compete? So my caution to policymakers is, whenever you hear these buzzwords, which are just pure pejoratives, ask the people who are telling you about them for specifics. Ask them, what exactly is a patent troll that you have in mind? Who are those people? What is the actual evidence, and how actually are they harming folks? And what is the actual harm in the marketplace? And then once we have identified those with evidence behind them, we can start talking about policy specifics. But waving arms with pejorative terminology has proven to be harmful and should be avoided.
Quick thoughts on perhaps the eBay decision or the Arthrex decision?
Well, so I'll let Adam comment on Arthrex, but just to go back to the Supreme Court, the body of Supreme Court precedent over the past 15 years on patent issues. I mean, when I think about the tragedies, if you will, around the weakening of the patent system, it's the fact that we have a Supreme Court that fundamentally does not seem to understand why patents exist. And I think eBay was sort of may have been, I could be wrong about this, Adam, but that was 2006. It was probably one of the first decisions by the Supreme Court that was sort of a bellwether of what was to come. And, the decision was written by Justice Thomas, who I think not only mischaracterized the sort of history around injunctive relief, but fundamentally did not seem to understand why we have patent remedies based on injunctive relief. And so, I think you could argue that the decision itself created some opportunity for patent owners to continue to obtain injunctive relief, but the way that decision has been interpreted by the district courts, it's almost become a sort of categorical rule against injunctive relief, which again, if you read the opinion, Justice Thomas was
Instead of
not
the
in
working in assumption that you're entitled to an injunction, the working in assumption is you're not.
Right, and again, if you think about the role of the injunction, and this kind of goes back to your question about a litigation, I mean, the last thing a patent owner wants to do is engage in litigation, particularly if you're a startup. I mean, a litigation it's almost game over. And now we've created a patent system without access to injunctive relief, where your only viable means of enforcing your patent right is to go to court. And for a lot of smaller entities, that just takes them out of the game altogether. Even for large companies like Qualcomm, the prospect of getting an injunction in this country feels remote at best. And again, the role of the injunction is to create an incentive for users of your patented technology to come to the negotiating table. So you don't have to go to court, and you don't have to rely on damages, which, despite what courts seem to believe, are not an adequate remedy for patent infringement. So, again, eBay to me was kind of a harbinger of a fundamental shift in this country's treatment of patent owners and its view towards patent rights. And we've only seen that, unfortunately, that trend line to continue in a downward direction. So when you talk about litigation, John, to me, it's just, it's first of all, I don't think there is any evidence of abusive litigation in any sort of meaningful extent in this country. If anything, I think the abuse, if you will, is companies willfully engaging in patent infringement, knowing that the patent owner, unless it's a very large entity, is not going to be able to enforce their rights. So if we're going to talk about abuse, let's talk about the abuse of property rights in this country that has really, I think, had a dramatic chilling effect on the willingness of the private sector and universities to make big investments in R&D.
Adam, I want to make sure we get time for at least one audience question, but do you have any very quick thoughts on Arthrex?
Yeah, just very quickly. So the Arthrex decision, which is now one of 4 U.S. Supreme Court decisions arising out of the PTAB, which was only went into operations in 2012, so this is less than 10 years ago, reaffirmed and reconfirmed that patents, at least as implemented through this administrative agency and through the structures created in the American Invents Act of 2011, which created the PTAB, are really now part and parcel of the administrative state. That the Supreme Court takes very seriously that the PTAB is an administrative agency, and so it's going to have applied to it all of the basic standards and operating norms that are applied to other agencies, including political control by the agency head, and extreme deference, as we know by the term Chevron deference, to agency-type decisions. And that's a type of indeterminacy and variance in kind of the nature of the rights that the patent system was, up until 2011, largely segregated off from and excluded from. Patents, as I mentioned, were treated largely as private property rights. They were adjudicated in Article III courts. They had all the norms and regular rules applied to them, as I found in my scholarship, from real property cases and other property cases. And so, again, this is the destabilization of the underlying legal infrastructure that's necessary to create the knowledge infrastructure, the innovation infrastructure, and the commercial infrastructure that drives our innovation economy. And so this is very concerning, and because you won't see the effects of it for another 10 years or so. But 10 years from now, given people have a political memory often of like 4 months, they won't connect the dots, unfortunately.
So I want to see if we have any questions. Do we have any from our Jessica? Does anyone of our virtual attendees have a question? Microphone doesn't appear to be working.
So hopefully
Okay.
they'll turn it on here shortly. Thank you.
No.
What message can we infer from the Biden administration's likely nomination of Marcus Delgado to the U.S. Patent and Trademark Office? And the panel discussed at length the administration's disappointing TRIPS waiver position, but do you think that this is indicative of an overall position on IP from the administration or just an outlier?
Who wants to tackle with that one first?
As the academic, I can quickly comment on the potential Delgado appointment. I don't know Mr. Delgado personally, but I know of his employer, Cox, professionally very well. They have long been a participant in the policy debates and legal debates that have created these narratives that have been highlighted, I think, very well by Andre and Lori, that patents are, and intellectual property rights more generally, are a problem, are a blockade, undermine creativity and innovation, and in fact, Cox engages in the type of predatory infringement practices that Lori mentioned, and we know that for a fact. They had a $1 billion copyright infringement judgment brought against them, or actually a verdict reached against them through a trial. And so it's concerning that he is going to be put at the head of the agency that is in charge of developing intellectual property policy, and particularly patent policy in this country, and especially given now the political control that the director has over the PTAB. We could see a continuation of a lot of the problems that we've talked about and have been highlighted.
Andre, Lori, any thoughts on that?
As a former nominee who's gone through the process, I'll just say don't believe the rumors until you see the actual evidence. It really is hard to tell. I don't know how accurate the rumors are. I just know from the past that these rumors the vast majority of the time are less accurate than they seem, but you never know. The other part of the question about the overall trend of the administration. Look, the WTO waiver proposal, as a general principle, is an extreme situation. We are in the middle of a historic pandemic. A lot of people are dying in the United States and around the world, and folks are scrambling to figure out everything possible in order to save more people's lives. So there are extreme pressures on the administration and other leaders around the world to make the right decision here when it comes to treating more and more people in a more and more equitable kind of a way. So I don't know if I would infer a broader scheme or broader IP perspective from the administration from that decision alone. The circumstances are just so unusual. But I would say that overall, I really would hope that the administration does recognize the historic importance of IP and overall not take risks to do things that are based on pure rhetoric and slogans without actual evidence. These issues are so important, and it's at such a critical time for the United States and its competitiveness in the world. The system overall in the arch of history has worked so well. Before making any radical changes, insist on evidence, both of the historic evidence that has happened, as well as the forward-looking evidence on which these decisions are made. The United States must stay competitive and maintain our technological lead, and all of these issues, IP in particular, feed directly into that. The stakes could not be higher.
If I could just add
sure.
one other, again, agree completely. I think it's, I do think the TRIPS waiver, that being sort of the first IP-related decision, high-profile decision by this administration, was very unfortunate, and I think it's also very unfortunate that that decision was made probably without any meaningful thought to the impact on patent rights, not just in this country, but globally. one of the things that often is not discussed in Washington as we debate issues around, patent litigation is what signal are we communicating to the rest of the world? Historically, the U.S. has represented a kind of gold standard, if you will, for intellectual property, played a hugely important role in encouraging other countries throughout the world to strengthen their intellectual property systems, to respect the rights of not just U.S. Intellectual property owners, but other, global intellectual property owners. And I worry that the TRIPS waiver, beyond all of the deficiencies that Adam outlined, sends a really problematic signal to the rest of the world in terms of the ability to essentially appropriate or create compulsory licensing regimes around important areas of technology. And I feel very confident, just having lived these issues for so long, that it won't, how that decision will be construed will not be limited to the vaccine situation, but will be construed as a sort of broader, opportunity to weaken patent rights, U.S. patent rights in important areas of innovation. So I think it's a disturbing decision on so many levels, but I really hope the administration, in addition to everything that Adam and Andre have communicated, that they recognize the important position that the U.S. plays in sort of signaling policy around intellectual property rights.
Well, sadly, as often happens, I have at least a half a dozen questions that I would have loved to have asked that I didn't get to, and I'm quite sure that our audience also falls into that category, but as often happens, the time has flown by. So please join me in thanking our panelists.